Welcome back to your daytime update in conversation with the Public Protector, Advocate Busisiwe Mkhwebane. Now here in daytime update, she's been appointed into this position in 2016, October, but since taking office, that office has seen a number of challenges. Herself, she's described it as testing times, including some what she calls as most unfair reporting in the media about the work of her office. Good afternoon, Advocate, and thank you so much for joining us.
Thank you so much.
Welcome to Newsroom Africa.
Okay, thank you so much, and afternoon to your listeners and viewers.
Testing times, are they continuing? Is the office of the Public Protector under attack?
I would say so, yes, it's under attack because I think people should be focusing on the good work which that office is doing. But unfortunately, there's a lot of focus on 5% of the work we are doing, and forgetting the 95% which we are doing, especially helping people at the grassroots. I mean, if you check that since 2016, we have received more than 62,000 complaints nationally, because we've got 9 provincial offices and regional offices of the Public Protector. And we finalized more than 43,000 of those complaints. So I think we should be focusing on the positives, because our office is very impactful on people at the grassroots. We are there especially dealing with the governance failure, because they are being failed, or the service failure, failed by local, provincial and national government.
Yeah. And
that's where we come in. So I would say there's few challenges we're facing because of this 5% of our work, which people are focusing on.
The third challenge, based on what you call the 5% of
the 5% relates to the investigations which we are conducting, which are relating to governance failure or conduct failure. Good governance and integrity branch of the Public Protector deals with those complaints, and that's where we deal with the complaints relating to the Executive Members Ethics Act, where we investigate the executive. So I think the media focus only on those, or where we are investigating tender irregularities involving exorbitant amounts, and where we have findings against institutions which most of the time they wouldn't want to be found to be wanting, then taking us on review, which is within their right. And that's where you would find that the media will focus more on those, but neglect the people at the grassroots, especially the people whom we are there for, since they can't afford to take the state to court or to exercise their rights as they would exercise if they had the resources to.
Let's talk about the current issue, because you do have the resources and the will and the know-how in terms of the legal processes that need to be followed. The current battle between yourself and Parliament. As of Thursday, you wrote a letter again via your lawyers to the Speaker, and you are, I mean, depending on how you read it, threatening in this letter the Speaker, Thandi Modise, via the lawyers, accusing her of unlawful actions and insisting that she acts on several of your demands. This emanates, of course, from the whole issue of the rules being put in place on how to remove heads of Chapter 9 institutions. What is the legal position from the Public Protector on this particular matter? Why are you insisting that these rules are illegal?
You know, Thabo, the process started last year when the leader of the opposition, the DA, which is the party which never supported my appointment, I think that everyone knows when I was appointed, last year when they raised the same challenges that I should be subjected to a process of inquiry to determine my fitness to hold office. And then I wrote to the Speaker, because also seeing the information in the public space, I then said to the Speaker, Section 194 of the Constitution would require you to come up with the rules or processes of how to remove a Chapter 9 institution. Then, by that time, then the Speaker agreed or followed our proposal.
Yeah.
So even this time, we've been seeing in the news that there are rules, they've been discussed, there's a rules committee, and in December 2019 the rules are adopted and by Parliament. I think people must realize that, or must take note that I'm not against the process of being subjected to any process by Parliament, and I'm not against it. I welcome it, but I'm also saying let those rules be compliant to the Constitution, in the sense that the rules were drafted, the rules were adopted, and all of a sudden the DA again is lodging the very same complaint, the very same DA which is against the appointment of the Public Protector Busisiwe Mkhwebane. And the challenge is, yes, it was saying Chapter 9 institution, but it was very clear that those rules were adopted or were drafted so that they can deal with the Public Protector. So I then, after hearing again that they have been adopted and the DA has complained, I wrote to the Speaker and indicated that it's the rules the way they appear, because we had to get them from Parliament through other members of Parliament. Yeah. And I then said to the office, or to my team, let's write to the Speaker again, as we did the last time, and inform the Speaker that these rules are not compliant to the Constitution. I mean, the way they are crafted.
I want us to move a little bit slower there. Are they far removed from the rules that we, as members of the media and as members of the public, are privy to in terms of what the process should be followed? Because there are rules that are being made available. They are on public domain at this particular point.
No, those are the same rules, and interestingly, those rules were drafted by the DA, and yes, they are the same rules which are there. The issue is we request that those rules, in the first place, as Chapter 9 institutions, we are not members of Parliament. As Chapter 9 institutions, we should have been given those rules to comment on, because issues of there's provisions relating to what is incapacity, for instance. I mean, they refer to even temporary incapacity. It means any member of a Chapter 9 institution, if you are involved in an accident or you have this sickness, then members of Parliament can just decide to remove you. Secondly, the rules are not very clear on what is incompetence, because at the end of the day, you cannot judge the Public Protector or any Chapter 9 institution on the merits of their investigation, because the Constitutional Court was very clear that any finding of the Public Protector must be taken on review and can be set aside by a court of law. Therefore, you cannot entertain the merits of the investigations of the Public Protector. Thirdly, those rules, I mean, what the DA is complaining about are things which happened prior the adoption of the rules. In law doesn't apply retrospectively. I mean, you need to apply the law moving forward. And another challenge is that the very same rules are not even dealing with, how do you deal with a conflict? Because the very same members of the DA, there's litigation which they are engaging with the Public Protector. Secondly, the very same members of the DA, I mean, you know, they allege that I'm a spy, I took them to court. That matter is still pending. Some of the ministers have been investigated. The president has been investigated. How do you deal with the conflict? And a lot of members of Parliament.
I mean, the rules provide for this, that the Speaker may appoint an independent panel, right, after all the parties represented in the National Assembly had a chance to forward their nominees. And that would be a panel that is not conflicted, because it would be independent. It would not be made up of members of the National Assembly.
And that is also contrary to the spirit of Section 194. Because our issue is these rules must comply, because it's the committee, the ad hoc committee of Parliament, which should deal with the hearing of the fitness of the Public Protector. It's not some panel. Yes, the panel, they are saying, is going to determine whether there's a prima facie matter, which is also interesting, because the Speaker is accepting the motion of the DA, because she's saying there's prima facie complaint. Why not bring it to the person?
Is entitled to her discretion in as far as the rules and the format and whether it fits a particular format in how it's being submitted to say there is prima facie evidence for this to go and be investigated.
You know, if you are conducting, you can't then just say it's a prima facie evidence. Better for you to say, I have accepted this matter, I will be referring it to the panel. But we're the very same panel, the way it's crafted. So the whole issue of the rules, the way is crafted, needs to be, analyzed and needs to be dealt with in such a way that they are comprehensive. And when they are adopted, are the rules which will cater for all the Chapter 9 institutions and will cater for all the issues which we have raised.
So let's get clarity on what you're saying. What you're saying, you are not against the process of the removal of a head of a Chapter 9 institution. You are concerned. Your concerns around, one, the way in which the rules were adopted, firstly, and the process of non-consultation, so to speak, for those parties who are involved to also have a say in these rules. Two, you are concerned about the constitutionality of the rules themselves. For example, how do you determine incapacity? One of the rules saying the inquiry will establish, according to the Constitution, the grounds for removal must be incapacity, incompetence, and misconduct. You're saying you need clarity on those issues, and those are the issues that you are taking to court.
Yes, those are the issues we are taking to court. Hence, we have interdicted the process, and the matter will be heard on the 17th of March. And after that process, there will be a hearing of a declarator, actually, to determine the constitutionality of those rules, but as well how Chapter 9 institutions should be protected by the Speaker. So because remember, they report to the Speaker.
Once again has admitted the motion by the DA, which, by the way, they took and then they resubmitted again.
That says a lot, because how do you submit a motion and it's adopted? You say it's a prima facie, and then you allow that motion be withdrawn. After the matter is before court, you don't use the court process, because, the matter is before court. We were expecting the Speaker and the DA to file their affidavit, because they are the two who are opposing the matter, and they didn't file. They requested an extension, which we didn't grant. And when they were supposed to file, then we were informed that the motion has been withdrawn and there's another one. There are also rules of Parliament which determine how to deal with matters which are before court. Rule 89 of Parliament, Rule 88 of Parliament as well, on how even the very same members of the Portfolio Committee of Parliament, especially the 5th administration, some of them of the DA are on the 6th administration, the way they pronounce themselves on the public protector. It's issues which are questionable, because already they've prejudged the whole process. But I think the main thing is, Thabo, is that the rules should be constitutional, the rules should be lawful, and in this particular instance, the Speaker is the one which is our key stakeholders as Chapter 9. The Speaker, in terms of Section 189, should be the one who's driving and leading the process of making sure that Chapter 9 institutions are protected. We can do our work without fear or favor and prejudice. But then when then you have to have these challenges, as I said, I tried again to write to the Speaker so that we can have an engagement away from the legal process.
Of what the state attorneys have said to your challenge. But to get criticism from the outside is one thing. To get criticism from within is something else. And I want us to deal with the criticism coming from within your office when we come back from the break. It is Advocate Busisiwe Mkhwebane with us here on your Daytime Update. You stay with us. We continue after this.